Let's just imagine that it did require, just work with me here. Let's assume that it did require some kind of communication. The agents were in his house, right? They were downstairs. Let's imagine instead of emailing it, he handed it to them. You would still say that all the offense conduct happened in his home in Washington.
Absolutely, yes.
Okay. How does it change matters? Again, just assuming that some kind of communication of the document is required, that he emailed it to them, so he could just say, for convenience, I'm just going to go ahead and email you the document as an attachment rather than physically handing it over. In your view, would that
In one of the most
change-
intense moments
how
inside
might
the Supreme
that
Court of the
change
United
matters,
States,
if at all?
Justice Amy
I don't
Coney
know that
Barrett
either
leaned
of
in
those
and asked a
scenarios are
question that
different.
instantly
Assuming that there
changed
is some sort
everything.
of communicative
It
element.
wasn't loud. It wasn't dramatic, but it was devastatingly precise. She asked the attorney a simple question. When exactly was a crime committed? Now, that might sound basic, but in law, timing is everything. Because if you can't clearly define when something happened, how can you prove that it was even a crime under the law at that time? The courtroom went quiet. The attorney began to respond, but almost immediately, it became clear this wasn't going to be an easy answer, because the case itself is built around a timeline that isn't so clear. Was the crime committed at the moment of action? Or at the moment the consequences were realized? Or somewhere in between? And that's exactly what Barrett was exposing. She wasn't just asking for a date or time. She was challenging the entire foundation of the argument. Because if the timing doesn't match the law, the case starts to fall apart. You could feel the pressure building. Every second the attorney hesitated, made the moment more intense. Because in front of the highest court in the country, hesitation is dangerous. Barrett kept pushing. Calm, focused, precise, not allowing the attorney to escape into vague explanations or general statements. She wanted clarity. She wanted a direct answer. And what made this moment so powerful is that it revealed something most people don't realize about Supreme Court arguments. These justices aren't passive listeners. They're actively testing every weakness, every gap, every inconsistency. And in this case, Barrett found one. A big one. Because if you can't clearly say when the crime happened, then how can the court decide if a crime even occurred under the law? This wasn't just a question. It was a turning point. And moments like this are why Supreme Court hearings are so fascinating. It's not always about long speeches or complicated arguments. Sometimes, it all comes down to one simple question that no one is fully prepared to answer. So what do you think? Was this just a technical detail? Or did Justice Barrett just expose a major flaw in the case? Comment below your thoughts. And if you want more intense courtroom breakdowns like this, make sure to like, subscribe, and stay tuned. Because the next question might be even more powerful.
In the statute, handing the piece of paper to someone versus emailing it to them, I think is communicating to the same extent. And so in either of those cases...
So we don't have to worry anything about a server. This is, it's going to their San Francisco server and their computer there and living on it in some way, right?
No, you do not have to worry about that, both because as a legal matter, the conduct would be the same, and also because there is no evidence in the record about where the government's servers actually are or were.
Okay,
the government, I think, is hoping that you'll assume that the servers are in San Francisco, but that was never asserted at trial. There's no evidence of it.
Okay, so you don't understand, and obviously we can ask Mr. Yang this when he stands up, but you don't understand the government to be contesting your interpretation of the statute and that only the creation of the document is required even if you put it in the drawer and never communicate it to anyone.
I do not understand the government to contest that, no.
And is that